CR 1505, State of Texas versus Otis McKane, present in the courtroom for the state.
Tamara Strauss, Mario Del Prado, and Jessica Schultz, present and ready for the state.
Defense.
Raymond Fuchs, Joel Perez, Daniel De La Garza, and the defendant in what proceed.
All right. And so I have a couple of questions for the parties. Have you had a reasonable time with the court's charge? I provided the court's charge on punishment several days back. Have you had a reasonable time? And if so, are there any objections, suggestions, or objections to the charge?
In its current form, Your Honor, not from the defense.
And Judge, we wanted to add the language yesterday pertaining to special issue number 2, but we'd ask that that be included. The language that we provided to the court.
Okay. And that was over.
Yes.
All right, anything else?
No, Your Honor.
All right, let's bring in the jury.
Adjourned. You be seated.
All right, welcome back, members of the jury. Hope you had a pleasant evening and a good morning so far. As I indicated to you, once when we closed the day last night or in the evening, I would read to you the charge this morning. So I'm going to read you the charge of the court on punishment. This is all the law that you will need in this particular case. Once I'm done reading the charge, each side will have an opportunity to present closing arguments to you. Now, the way we're going to do this is once I'm done and the attorneys have given you their closing arguments, then I'm going to instruct you to begin your deliberations. You'll exit the room, you'll go into the jury room, the bailiffs will talk to you for a second, then you'll come in here, we're going to clear the courtroom, and your deliberations will be in the courtroom, okay, and they will be in secret. And so I'm going to read you the charge of the court. Charge of the court on punishment. Members of the jury, with your verdict returned in this case, you have found the defendant, Otis McKane, guilty of the offense of capital murder as alleged in the indictment. You are instructed that a sentence of life without parole in the Texas Department of Criminal Justice or death is mandatory upon conviction of a capital felony. It is now your duty to consider all the evidence in this case and determine the answers to certain questions which will be set forth for your consideration. The questions will be termed issues in this charge and must be answered yes or no. The punishment to be assessed the defendant will be assessed based on your answers to these issues. You are instructed that the state must prove issue number 1 beyond a reasonable doubt. In deliberating upon issue number 1, you shall consider all evidence admitted at the guilt or innocence stage and the punishment stage, including evidence of the defendant's background or character or the circumstances of the offense that mitigates against the imposition of the death penalty. The jury may not answer issue number 1 yes, unless there is unanimous agreement of the 12 individual jurors upon that answer. The jury may not answer issue number 1 no, unless 10 or more of the 12 jurors agree upon that answer. In determining the answer to issue number 1, you are instructed that you need not agree on what particular evidence supports a negative answer to that issue. Issue number 1 is, do you find from the evidence beyond a reasonable doubt that there is a probability that the defendant, Otis Tyrone McKane, would commit criminal acts of violence that would constitute a continuing threat to society? Answer, we the jury unanimously find and determine that a reasonable doubt, the answer to issue number 1 is yes. Or, answer, we the jury, because at least 10 jurors have a reasonable doubt as to the probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society, answer issue number 1, no. You are instructed that if you return a verdict of no to issue number 1, then you will cease your deliberations and not answer issue number 2. You are further instructed that if you return a verdict of yes to issue number 1, only then are you to answer issue number 2, and your answer to issue number 2 shall be either yes or no. The jury may not answer issue number 2 no, unless there is unanimous agreement of the 12 individual jurors upon that answer. The jury may not answer issue number 2 yes, unless 10 or more of the 12 jurors agree on that answer. In determining the answer to issue number 2, you are instructed that you need not agree on what particular evidence supports an affirmative finding on that issue, and you shall consider mitigating evidence to be evidence that a juror might regard as reducing the defendant's moral blameworthiness. Issue number 2 is, state whether, taking into consideration all the evidence including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or are sufficient mitigating circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed. Answer, we the jury unanimously find and determine that the answer to issue number 2 is no, or answer, we the jury, because at least 10 jurors find that there is a sufficient circumstance or are sufficient mitigating circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed, answer issue number 2 yes. You are instructed that if you answer that a circumstance or circumstances warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed, the court will sentence a defendant to imprisonment in the Texas Department of Criminal Justice for life without parole. If the defendant is sentenced to confinement for life without parole, he is ineligible for release from the department on parole. If there is any evidence before you that the defendant may have committed any offense or act of misconduct other than the offense for which you have convicted him, you are instructed that, as to the evidence of an act or acts of misconduct for which the defendant has not been convicted, you may use that evidence, if any, in answering the issues submitted to you in this case, but only if you find from the evidence beyond a reasonable doubt that the defendant committed such other offense or act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such offense or act of misconduct was committed, or as to whether the defendant was involved in other such offense or act of misconduct, then you will wholly disregard the evidence of any which may relate to any such matter. You are instructed that the defendant may testify in his own behalf if he chooses to do so, but if he elects not to do so, that fact cannot be taken by you as a circumstance against him nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court which is herein given you, and be governed thereby. Respectfully submitted, Judge Ron Rangel, 379 Judicial District, Bexar County, Texas, and on the back are the 2 verdict forms. All right, State, are you ready to begin your closing argument?
Yes, Your Honor, we are. May it please the court, counsel, ladies and gentlemen.
This is a dangerous man. He is a dangerous man. And you've been here for several weeks, and you've heard all the evidence, and he's clearly a dangerous man. What makes him even more dangerous is that when he hears facts that he doesn't like, according to the defense team and their own expert, that provokes him. Their own expert agreed with me when I said, running up and coming at somebody from behind and shooting him from behind twice, that could be a cowardly act. He agreed with that. So when you call him what he is, that provokes him. You heard when y'all returned your verdict, that provokes him. And if he was so provoked by me calling him what he is, a chicken, a coward, whatever, can you imagine when he's in TDC and there's with 143 of his new best friends and there's a single unarmed guard and somebody says something to him, and let's face it, there's probably going to be a lot more colorful language than coward floating around down there. So if he gets provoked in a court of law with all of this security, armed law enforcement, what do you think he's going to do with a single guard and 143 other inmates, and the guard is unarmed? What do you think he's going to do? And remember, when he was provoked, and they wanted to point out to you that I provoked him, he doesn't come after me. I was standing right here. He could have come after me. What does he do? No. He goes after an innocent law enforcement officer. That makes no sense. But that just shows, once again, the defendant's hatred for law enforcement, which has been consistent throughout the presentation of the evidence. One of the things I don't want you to forget is when Dr. Arambula was talking about, and of course their expert didn't review it, all of the communications this man had with a man named John Davis, who hated law enforcement. And he tells you, the defendant's talking about his hatred for the system and law enforcement, and all these letters are going back and forth. The reason he behaved in court and you didn't see him act out beforehand, because they said, he's been in jail all this time and there have been no problems. Remember, he's been under lock and key for 23 hours a day. When he gets out for 1 hour, he's never around any other inmates. And there are 2 guards with him. And usually he's restrained. And he knows he has to behave. So he's got very little opportunity to act out. But once you convicted him, that provoked him, and he reverted to who he really is. And who he's been his whole life. And it's not his mother's fault. It's not his family's fault. And when you look at the special issues about this concerns his moral blameworthiness, not his family's. Are there sufficient mitigating circumstances for him, not his family? His brother seemed like a great young kid. And he says what the defendant does for him. The problem is, once again, what kind of example is this man setting? And he set his whole life. Takes no responsibility, been lying and deceitful his whole life, works the system, shows no remorse, and continues to deny that he committed the offense. What kind of message does that send to his family? And you heard his family talking to him on the phone, saying, hey, do you realize your actions? How that hurts us? Think about us. And one of them said something about, think about Jesus and surrender. And his response was, I don't agree with you. I don't agree with you. I got to stand my ground. And then he describes himself as a ferocious dog. You know, I called him a coward, which the facts bear out. He refers to himself as a ferocious dog. He refers to himself as a bowl of acid. And we all know what acid does. We've all seen the horrible pictures of people who've been burned with acid. It destroys. And he refers to himself as a bowl of acid, a thinking bowl of acid, because he's a thinking man. He wanted to make clear he's a thinking man. And what did Dr. Arambula say? Thoughts precede action. I mean, even their own expert said, yeah, he knew what he was doing. He knew right from wrong. So, that's what you need to think about. The special issues boil down to this, and we'll go over them. Special issue number 1, have we proven to you beyond a reasonable doubt that there's a probability that he'll commit criminal acts of violence that would constitute a continuing threat to society? Well, and you know, we've been together a long time, and we talked to you guys a long time ago. And you may remember that the majority of our questions to you concerned the special issues. And the defense was asking you things like, well, what if, if he destroys somebody's property, or if he yells at a guard, the state's going to say that's an act of violence. How can you predict if he's going to act out in a violent manner? Well, 44 seconds after y'all walked out of the room, he reverted to his character. He was provoked. We don't have to sit here and wait and count off a minute 49 seconds like Mr. Pettis had y'all do. 44 seconds is a really short period of time. Y'all probably all hadn't even had a chance to get seated in the room back there. And what was it again? It was another unprovoked, deliberate attack on a law enforcement officer. Isn't that curious? That's who Otis McKane is. And that's who he's always going to be. Dr. Arambula told you he suffers from antisocial personality disorder. He's a sociopath. He takes no responsibility. He lies. He's never been responsible to his family or his son. I mean, we can go over and over all of that irresponsibility. I mean, just the guy's making, $1,200 a week as a drug dealer, $380-something on his car, $1,400 on his rims. Look at the Saha records. The San Antonio Housing Authority records are in evidence. Look at those, and you'll see he's paying, at most, $14 a month for his apartment. And sometimes he says, I get it free. And the reason that happens is because he tells the Saha people, like he's required to, you've got to tell them when you're working. And so when you look at the records, the initial entry is he doesn't have any income, he says, except his mother pays him $200 a month to babysit his little brother. He's charging his mother $200 a month to babysit his little brother. Of course, he didn't include his money from his drug dealing. But you'll see he says, I work at McDonald's. He looked like he worked at McDonald's for a week or two. Then it looked like he said, I lost that job. Then I got a job at Jimmy John's. He had that for a week or two. Everything you've heard about him hits all 7 criteria for antisocial personality disorder. And before the age of 15, when he was 13, his life of violence kicked off when he pulled a 12-inch butcher knife on a family member because he wanted the last hamburger. And he told the reporting officer, I wanted to cut him. Okay? Then, of course, we know about Zaharia and the way he treats women. And, even she talked about the verbal and physical abuse. But as you can see, she was talking about he doesn't like it when you talk to him in a certain way. Just like he doesn't like it when he hears facts about himself. He doesn't like that. He gets provoked. And we know what he does when he's provoked. And these are the people who have to deal with his provocation. You saw what happens when Otis McKane gets provoked. 12 law enforcement officers, armed, not like the unarmed ones in TDC, 12 armed law enforcement officers had to go in there and restrain him. That is, and all the rest of us, we're like, everybody else is getting away. And the bailiff said, we were afraid he was going to go for a gun. Of course, nobody here, outside of law enforcement, wants to be around if he gets a hold of a gun. But who's rushing towards him while we're all running away? It's the law enforcement. They're standing watch over him. So in TDC, that guard is not going to be armed. And there's not going to be 12 of them. And there's going to be 143 other people. I don't even know that there's 144 people in this courtroom. So you can imagine this courtroom full of inmates and one unarmed guard watching this man who gets provoked and will attack you if you say something he does not like. So, you look at the crime first. Look at the crime. It was planned. It was heinous. And it was unspeakable. And the thing I want to say about unspeakable is this. When you see that what he did to Detective Marconi, words cannot describe that at all. You see it and words cannot describe it. That's why you have a term like unspeakable. And frankly, it was so offensive to hear Dr. Crowder say, well, of course he didn't do anything. Didn't look at anything. He wants to tell you this man is not going to be a danger. He didn't even look to see what he did. Oh, I could just read the reports. Okay? But when you look at that, it's unspeakable. And one of the things we don't want you to lose track of in this case is it's so easy to forget Ben Marconi. Because he's not here. Yeah, we may have a picture or two for y'all to see. But Mr. McKane is sitting in front of you, and his family comes in, and it's very easy to feel for him. I mean, I feel for his family, but we're talking about his moral blameworthiness, not his family's. And they're still having to listen to him say, I didn't do this. I'm innocent. The state framed me. They added stuff onto my confession, Photoshop. We brought NASA in, and they engaged in a conspiracy with us to make that vehicle look like his. And you've heard from everybody, he is not suffering from a mental illness. He's got a mental condition. It's a lifelong mental condition. Even Dr. Crowder said it's notoriously difficult to treat. He's going to have it his whole life. But both Crowder and Dr. Arambula said it's a choice. He knows right from wrong. That is a choice that Mr. McKane is making. What I want to say about Ben Marconi is it's horrible, obviously, the way he died. He didn't even see it coming. And as Dr. Simon told you, after that first shot, he felt pain. He was conscious. Y'all remember, he puts his hand up. And we can only wonder what was going through his mind at that time. One of the things that I've heard by several theologians when they talk about things that are unspeakable, the name of God used to be unspeakable. You couldn't say the name because it was unspeakable. So the Israelis the name was Yahweh. And a lot of theologians say Yahweh came from the fact that when you breathe in and you breathe out, it sounds like Yahweh, Yahweh. So hopefully, the last thing that Ben Marconi experienced before he was executed by this man was he had the name of God on his lips. Two, you look at the criminal. And, and going back to one for a minute, it's beyond all doubt that he's a danger, and y'all saw that. We don't have to predict things, and, Dr. Crowder kept going back, well, there's not a probability. My gosh, how is there not a probability when we know he did it? We know he engaged in a criminal act immediately, a violent criminal act against a law enforcement officer. Couldn't even wait a minute. So that is, I would suggest, special issue number 1 is kind of an open and closed case. He's a danger. 2, you look at the criminal. He's a sociopath. And you remember all the criteria about that, and everything you've heard about him in his life, and what he does, and what he hasn't done, is consistent with that. Dr. Arambula said personality is a constant. One of the things every one of you talked about when you were selected on this jury, when we talked about whether or not somebody should get the death penalty in the appropriate case, and you all said in the appropriate case, you all took a note saying you could do that, was the issue of remorse. Remember number 7 on antisocial personality disorder. They don't show remorse. How can you show remorse when you didn't do it? So, and obviously the ticking time bomb, he goes off when he gets provoked. It can happen at any time. That one of the things they may talk about, well, Dr. Crowder loved talking about studies. Didn't want to talk about this individual's violent past, but he wanted to talk about studies. And he was citing these studies, but he didn't tell you that the study he was citing to you, where they followed prisoners to see if they were going to be a danger or commit an act of violence, they followed them for 1 year. He didn't tell you that. He said, no, yeah, I had to ask him. Oh, that wasn't important for the jury to know? The reason that's important is because for 4.5 years, this man's been under lock and key 23 hours a day. So, if he were a part of that study, yeah, for a year, he wouldn't have shown any danger. Issue 2, considering all the evidence, the circumstances of the offense, and when y'all were selected on the jury, we went over the law with all of you, saying that, and y'all were qualified to be on this jury, when you agreed that in an appropriate case, the circumstances of the crime could be enough to return the death penalty in an appropriate case. That some facts are so cold and calculated and cruel that in and of themselves, it deserves a death penalty. And then you look at the defendant's character and background, and I suggest to you there is nothing whatsoever that is mitigating about his character and background. I would suggest what you've heard is aggravating. It makes him look worse. And his personal moral culpability, it's off the charts. I mean, we can go over and over the evidence, the continual lying to Detective Duke, and then the gut-wrenching statements he makes about wanting the police department to feel the burn. Could have been anybody, but he had to lash out at the police department. Could have been a 21-year-old rookie. Could have been a Bexar County Sheriff's deputy who has to guard him. And probably the most scary thing that Otis McKane said was that soothes his soul. Violence soothes his soul. Remember when that phone call with his mother, he's saying, "Oh, those guys beat me up. 8 guards beat me up." And his mom's like, "What?" And then you can hear him, he starts laughing. He thinks it's funny. He thinks it's funny. And then he says, "Oh, there's no hard feelings. There's no hard feelings. These guys don't have any hard feelings against me." Do you think that's true? Sufficient mitigating circumstances, I would suggest to you, there are none. I would suggest they're going to come to you and say, "What about the family?" And once again, I feel for the family. But it's not the family's moral blameworthiness. It's his. He needs to stop pushing the blame and responsibility onto someone else like he's done his whole life. Remember, for him, it's always somebody else's fault. "Zaharia, you're making me do this to you." Okay? The system made him strike back. He hasn't ever been held responsible. So please do not let him skate once again because of his family. And if you sent him to TDC, I think some of the most eye-opening testimony in this case was from Steve Bryant, the regional director of TDC. First of all, this is called the punishment phase of the trial. That's why we're here. And we asked him, "Well, what's in the mission statement of the Texas Department of Corrections?" The word punishment does not appear there. They are not there to punish people. His life the quality of his life will increase 1,000% if you give him life without parole. You heard everything that he's going to be able to do. He'll only have to be in his cell when he goes to sleep. Other than that, he's got complete access to the prison. He could be around someone who's serving as little as 2 years in prison. He's not only going to be around the guards, he's going to be around clerks and the janitorial staff and the school teachers and all the volunteers and the physicians and nurses and everyone else who has to run that basically small city. Like Dr. Randall was saying, he's been in there. And those people are what? They're walking around, 144 people with one unarmed guard. He's going to be able to go to school. He's going to be able to take college classes. He's going to be able to have visits with his family, contact visits. I'm sure the Marconis would like to have that. He's going to be able to continue to see his family, even if you give him the death penalty. He's going to be able to continue to see his family. And actually, the ironic thing is, if he gets a death penalty, the quality of his life improves anyway. Because on death row, it's 22 hours in and 2 hours out. and the recreation is better than in the Bexar County Jail. So no matter what you do, the quality of his life improves. But besides, the school and the medical and the dental and the educational, he's going to work. Can you imagine Mr. McKane being given a job in the kitchen with all the implements that are in the kitchen? We know he knows how to make a shank. It came out of his own mouth. Remember that when he was talking to his mom and he was angry? And he said, let's tear it up. Let's do it. I can bust down this light bulb and make a shank. So please consider that when you make your decision. Who you're going to be sentencing to have to deal with Otis McKane. Because people are going to have to be around him. He's going to have a cellmate. He's going to be in the day room. He's going to be in the dining rooms. He's going to be on the rec yard. He's going to have a run of the religious facilities. Please consider that. Special issues, I suggest the answer to special issue 1 is beyond any doubt, beyond a shadow of a doubt, beyond all doubt is yes. And that the answer to special issue number 2 on sufficient mitigation, I suggest there is no mitigation. And there is not sufficient. And then when you look at that, then you have to, it's just not the end of the inquiry there. You have to weigh that against the circumstances of the offense, his character and background, and his personal moral culpability. The past matters. We hear about this future, what's going to happen in the future with Mr. McKane. The past matters. Okay, let's not forget that. What happened in the past matters. Benjamin Marconi's 50 years on this earth matter. Benjamin Marconi mattered. He mattered to his friends and family and co-workers at the police department. He mattered to the kids at the Alizon Apache Courts who called him Officer Macaroni. He mattered because he's the kind of man who went in and saved a child. And we're only human, but it's so easy to forget that because he's not here. And in this short time, even in the 3 or 4 weeks we've been together, that is not enough time for you to understand the life of a man like Ben Marconi, the 50 years. I mean, it's really a disgrace that you get to know so little about him. But the past matters. And this quote by Mary Oliver, tell me what it is you plan to do with your one wild and precious life. Well, we know what Ben Marconi did. It's unfortunate that it was cut short at 50 years. He hasn't met the rest of his grandchildren, his family, for the rest of their lives. They're going to mourn him. Cowards die many times before their deaths, but the valiant, like Ben Marconi, only tasted death but once. There was another famous sociopath who once said, remorse for what? This is a quote from him. Remorse for what?
Objection, Your Honor. That's not a reasonable deduction of the evidence, and it's not an evidence. Whatever another person said, you can't apply to him.
It is a well-known public figure. I'm not naming him. It is in the public arena, Judge. We can use literature, allusions to literature, in argument.
Maybe you want to clear that up a little more.
Well, do you want me to say who it's? This is a quote by Charles Manson. Okay, Charlie Manson said this. Same diagnosis as Otis. Remorse for what? You people have done everything in the world to me. Doesn't that give me equal right to do now what I do to you? James Baldwin said, the most dangerous creation of any society is a man who has nothing to lose. Mr. McKane has nothing to lose now. You convicted him. He has nothing to lose. The attack on the guard, that's a felony. That's a felony. But what are you going to do? What are they going to do? Are they going to stack prison time on top of a man if you give him life without parole? He's going to think that's a joke. What are you going to do to me? Give me more time? He has nothing to lose. That's why he acted out as soon as you told him your verdict. He has nothing to lose. That makes him even more dangerous. Ben Marconi's stepdaughter, JC, when she got up here, talked about something like this. And the manner of his death has now and forever defined his life and how he lived it. And it's redefined who Ben Marconi is. That balloon, to me, signifies the life of Ben Marconi. And now, for the rest of their lives, everyone who knew Ben Marconi is going to have to be dragging around the anchor of Otis McKane. I think we've all had experiences like there's a song by Jim Croce, who probably all y'all are too young to remember. But every time I hear it, it takes me back to where I first heard it in high school in an auditorium. Doesn't matter. I mean, it's all the same thing. It's that neural pathway burning. They hear it, and it's that connection. That's what's going to happen, unfortunately, for these people. I mean, it's happened with us. Mr. Pettis the other day, he referred to him as Otis Marconi. They are going to be forever melded together, to the great detriment and loss of the Marconi family. And you can consider that when you're determining his personal moral culpability. I already went over that. This is another quote from a famous poet. When someone shows you who they are, believe them the first time. One of the last things I want to talk to you about is the defense expert, Dr. Crowder. I would suggest that you saw that man was on this case for 4 years. And frankly, I don't know what he did, because he certainly didn't look at any of the evidence. I mean,
That's a misstatement, not truthful, Your Honor.
he kept asking me.
Misleading the jury. He said he didn't see any of the evidence he said.
Well, the jury's going to remember the testimony in this case.
Do you recall him continuing to ask me, well, I haven't seen that, but do you want to show it to me? What kind of preparation is that? How can you believe anything that comes out of that man's mouth? And then he makes these ridiculous assertions like, oh, I know he was under the influence of K2. I want you to go back and see where he says there was K2 involved. Everything he got comes out of the mouth of Otis McKane, or Otis's mother and sisters. And when Otis's mother came in here, the only thing that she said was, well, one day I heard him talking to himself in his bedroom. That's the only thing she told you. You didn't hear from the sisters. But Crowder wants to say, oh no, he was suffering from a psychosis. And isn't that, I mean, I brought it up to him. How in the world can you say he was suffering from a psychosis and that's why he did it, and then have him say, I didn't do it. I didn't do it. I mean, you can't ride those two horses, but they're trying. The last thing, the only thing I think that Crowder can be believed about is when I asked him after we went through paranoid personality disorder. And you remember, they didn't have to hit all the criteria. They just had to hit enough. He's got paranoid personality disorder. Then we went through narcissistic personality disorder. He's got narcissistic personality disorder. Then we went through antisocial personality disorder. He's got that too. And then I asked Crowder, I said, well, doesn't the literature say that if he has all three, he's a psychopath? And I don't know if you recall, he got very uncomfortable. And then he said, oh, well, yeah, he does share characteristics with psychopaths. And on the test, he got 19 out of 30. Okay. See, Dr. Ramula said he's a sociopath. I mean, not that that makes him any better. They're basically birds of a feather. So I think anything, and how can Crowder say, I know what was going on in this man's mind. I know he was on drugs. He doesn't know what he was doing on the 20th or the 21st or the 19th or anything. How could he know when he doesn't even have the decency to look at any of the evidence in this case, any of the videos? It was embarrassing, frankly. I felt bad for him. The last thing I want to tell you is, Mr. Pettis got up in front of you in guilt innocence and said, remember, Otis came clean with you. He came clean and he apologized for the Marconi family. You were told that in guilt innocence. He came clean and he apologized. So remember now what he's been doing for the last 4.5 years. Starting with 2 weeks after he's in jail, and he tells the KINS 5 journalist, who says, what do you think should happen to you? And his response, I think I should walk out that front door. I think I should walk out that front door. How does that make you feel? Fast forward 4.5 years, y'all come back with an appropriately swift verdict. He acts out once again. Then he's on the phone telling his mother and his sisters, I'm innocent. And his little brother, I'm innocent. I'm innocent. Told Crowder the same thing. I'm innocent. Y'all took an oath in an appropriate case to do the right thing, to do justice. Nobody's saying it's going to be easy, but we're asking you to follow your oath and follow the law and follow the special issues. It's not your fault that Otis McKane has made the answers to these questions abundantly clear. Do justice, do your job. And the last thing I want to say is we do thank you for your time. This has been difficult, especially with all the COVID issues. And you've been here a long time. And we presented a lot of evidence to you. And I'm sure there were times where y'all were thinking, oh my God, can't they shut up? But we had to bring everything to you to show that, look, we're not trying to railroad somebody. We wanted to bring everything to you. And we wanted to show you that there were times where we were looking for evidence and maybe we couldn't find it. Like with the NASA guy. Yeah, we would have liked to have had the license plate, but come on, we didn't need it. The evidence is overwhelming. He's the guy that did it, and y'all know that. And y'all know, I believe in your hearts, when you look at the evidence, what the appropriate punishment should be for him. Thank you.
I just want to make for the record.
You can't do
I
that.
choose to testify.
You can't do that right now. Defense, you got closing.
Please, court. Counsel. Ladies and gentlemen of the jury. The judge has told you this phase of the trial is referred to as closing argument. I don't want to argue with anybody. I don't want to even argue with these prosecutors anymore. What I want to do is talk to you about this and perhaps persuade some of you who have heard all this evidence that the state has not proven the answer to that special issue beyond a reasonable doubt, that it should be yes. And of course, as he says, the past matters. And we start with the first incident of an assaultive conduct is this incident when he's 13 years old with his cousin taking the last hamburger that he had to go home as a middle school student and cook for his family. And yeah, he says, I wanted to cut him, but he did not. He did not cut him. I don't know how anybody here other than myself grew up, but I can see that circumstance where the cops would never have been called, nobody would have been put on juvenile probation, nobody would have been stuck out at the juvenile detention center for that. But that's what happened in this case. He said, oh, I wanted to cut him. But I think it's very important that he did not. Then the next thing that happens in his life that is meaningful in this case is the arrest in Concho County, Texas for possession of cocaine. Okay. Now you remember Saharia's father testified that he said he was on possession for selling crack. I mean, on probation for selling crack. But that's not the case. It was possession. And he got probation in Concho County, Texas for that offense, which suggests it may not have been very serious at all. He's on probation near the expiration when he has met Saharia. And they get into this relationship and she bears a child. And she testified that it was a very volatile, tumultuous relationship. But I'm suggesting to you by her own testimony, it was a two-way street. When asked about throwing batteries at Otis, she said, I don't want to answer that. Well, obviously the answer was not no. Horrible relationship. She ends up getting a protective order against him. And then she ends up telling him, the rules have been changed. You now have to have this supervised visitation. No judge said that. No court order said that. That was a unilateral decision on her part to have him not see his child. When he was at that McDonald's with that child and was walking out to the bus stop with that child, he had every legal right to do that. Somehow or another, her father appears right away, puts him in a chokehold, and the child is released. Now, at some point, Saharia's father, I'm sorry, I can't remember his name right now, said that he put up both his fists at him, but he's still holding the child. So there's a little bit of elaboration there to make him look worse. And Saharia made it want him to look worse. And another thing I want to tell you right now is what we say in this case, what we tell you, what this prosecutor has already told you, is not evidence. The evidence must have come from that stand. And speaking of the incident with Saharia, where they're going like 30 miles an hour and he pulls the car off the road, well, sorry, not off the road. Apparently she put on the brakes, the car stopped. And he kept asking Dr. Crowder, well, what about a man who threatens to kill a woman and her child? And he didn't keep telling you what Saharia said. She said he said he was going to kill me, the child, and himself. That is absolutely, he's right about him being a narcissist. That's a narcissist statement. But also like a narcissist, Saharia is quite alive, the child is quite alive. It was another threat that was not consummated. Okay? Now, after Saharia and all that, at some point in time, once the protective order's out, that's pretty much done. Because I want to point out to you how situational these things are. The first one, when he was 13, it's situational over, here are people in poverty and somebody's eating food that may have been for somebody else, and he reacts against a larger individual, his cousin. And this idea that it's a 12-inch butcher knife is not in evidence. Okay? All of a sudden, whatever knife it was becomes a 12-inch butcher knife. No one testified to that. And the cross-examination of Dr. Crowder, when he was talking about, well, I want to go back to the sequence of events. So then, at some point, Otis McKane has not seen the child or Zaharia for 2 years, and there's no more violence between them. Again, these things are situational. Okay? The murder of Benjamin Marconi is tragic, wrong, and evil. No one disputes that. No one disputes that that man did not deserve that. No one disputes that his family should not have to live with that. I mean, that's not a question. The question now is, what is going to happen to Otis McKane? You know, if you give him life imprisonment or the death penalty, the family's still going to have that anchor of him in their life. But the question here is, what do we do with Otis McKane, and what does the evidence show you? After Otis had spent a little over 4.5 years in what is referred to as solitary confinement, it would appear that he became delusional about the result or outcome of the case. And I guess if you're locked up in a little room for 23 hours a day, one can have delusions of freedom. And this went on for 4.5 years. And every day we picked that jury. And it took us, I think, 38, 39, 40 days, I don't remember the exact number, of days to do that. 2 bailiffs would bring Otis McKane to the central jury room. Every one of you, that's where we picked the jury. Every day. They escorted him during breaks. They escorted him when we took lunch. They escorted him when he came back. And they escorted him back. And it wasn't into a little holdover cell like this. If you recall, coming into that central jury room, there's long hallways, elevators are over there. So it wasn't like he never had an opportunity. If this thing about he hates law enforcement so much that any time he sees a uniform, he's got to strike out. There have been more than 60 occasions now where he's been brought back and forth to court, and we have this one incident. And what I want to impress is that here he is, the solitary confinement, obviously getting delusional in there. He comes to court, he hears this evidence against him, and yes, the purpose of Mr. Del Prado of going over and pointing at him is to goad him. There is no other reason for it. None. You know, I don't know anyone that likes someone to come up and point a finger at them and call them names, okay? Even if they are that person. Who wants to do that? So here, then the jury, y'all come back with your verdict, guilty, and came back with it quickly. If you see that video, or if you recall it, I am approaching the bench, Mr. Bettis is approaching the bench, and he's telling the bailiffs, leave him there. We're going to talk to him. Leave him there. We're up here discussing the matter, and the deputies decide, no, he took off his tie, he took off his shirt, it looks like he's going to be a threat, so let's drag him out of here. That was a situational event. He will never ever again have this illusion or delusion of freedom. He will never ever again have any hope of seeing his son again. The idea that he might have visitors at TDC, you know, 2 of them will not be Zaharia and his son. So he knows that's never going to happen again. And the verdict of guilty, he knows he will never be a free man again. And so that was what he reacted to. He did not strike out at law enforcement. And Mr. Del Prado says, well, I'm standing right here pointing at him. Why didn't he attack me? Because all those other events had not occurred when he's doing that. It's the pointing at him, the goading him, then the verdict, then all these thoughts going through his mind about this is all over. This, I'll never be free. I'll never see my son. And now he's saying, I don't even get to talk to my lawyers. And it was a reaction. There's no indication. Oh, and why did he strike out at a peace officer rather than Mr. Del Prado? Because there's 12 of them around him. That's who's grabbing him. That's who's throwing him into the holdover cell. That's the only person near him. That's why it was a law enforcement officer. Not because he's got this, I hate every cop I see. I hate any authority I'm near. I hate this. That's just not the evidence. And this idea the deputy is afraid he might get my gun. That may have been a fear of the deputy, but there is zero evidence that he went for anybody's gun. None. But they want to say, oh, they had guns, he's going for the gun. Didn't happen. Regarding the conditions at TDC, a fellow that Mr. Bryan, I believe his name is, came in and talked about how things work at TDC, how they classify people, how they come in and out, how they move around the prison campus, I guess you could call it. TDC can also put somebody in a category where they don't have all that freedom, where they are locked up for most of the day, where they have limited privileges. And the statement, too, here's one statement that is absolutely a false representation. That witness testified, a person serving life without parole. This is a very minor issue, but I just want to point out what we say is not the evidence. He said a person serving life without parole cannot be involved in food services. Yet Mr. Del Prado is telling you, can you imagine this guy in the kitchen? He's never going to be in the kitchen. Now, Mr. Del Prado talked to you about how he found Dr. Crowder to be incredible because he had not seen a couple of videos. Now, he tells you the man looked at none of the evidence in the case. That's not true. What you're saying is, no, I haven't seen those videos. Well, for some of us, the book is better than the movie. When Dr. Crowder testified, I read the reports. If I see the video, I just see what's on the video. But by reading the reports, I can see what all the other people who aren't even in the video have to say about what happened. That's why sometimes books are a lot better than movies. And he wants you to be impressed with Dr. Arambula's incorrect diagnosis. This is I want to point out something to you. Dr. Crowder said, I talked to Otis McKane on 3 occasions. I can't remember the total hours, but it was something like 7 hours, 8 hours, I don't remember. Dr. Arambula said, I never talked to the man. Okay? He never even tried to talk to Otis McKane. Never. He was hired after this trial began. And I don't know if that's when the state found out that they're over their 2 witnesses, Dr. Fabian, a psychiatrist, Dr. Clem, a forensic psychologist. And you heard Dr. Crowder said, yeah, I've seen their reports. They don't say he's a sociopath. They don't say he's a psychopath. As a matter of fact, they said he was suffering from cannabis use disorder and unspecified adjustment order. There's no, he's a sociopath. He's got antisocial personality disorder. The only one who checked all 7 boxes was the guy who never talked to him. You have 3 mental health experts saying he's not that way. But the state chose only to call 1. Now, they may say, well, the defense can call him, but we don't have to. We don't have the burden, okay? We don't have to call the hired experts of the state. There's no reason to disbelieve any word Dr. Crowder told you. The idea that somebody might possibly do something is not what this special issue addresses. What this special issue asks you, has the state proven to me, beyond a reasonable doubt, that this person is probably going to commit criminal acts, not an act, acts of violence, so that he's a continuing threat. And every incident in this case, once the situation ended, the threat ended. And I submit to you, the state has not even come close to proving that he is a future danger. Thank you.
Good morning, ladies and gentlemen. First of all, we've been with you now since March of 2020. If you remember at the voir dire, when we spoke to you, the state did the PowerPoint and all that. And then we got you guys, right? I mean, and you know, we went through like 160 of you, I think. And so we were there a lot of times, right? And I would say that we spent a small amount of time on guilt innocence. We focused on your views on the death penalty. And if you recall, that's what we did. And I say that because when we came up here to argue the guilt innocence phase, we didn't come and tell you unreasonable things. As lawyers, in that phase of the trial, we're looking for reasonable doubt. We've known the evidence, they've known the evidence, and we saw what might be reasonable. You know, this saying, reasonable minds may differ, okay? And we didn't come up here and say, hey, someone put paint on this car, you know? We didn't come and say, hey, the car was photoshopped. We didn't come and say the video was edited and the Miranda rights were, inserted in there. We came and argued that potentially one of the elements of the capital murder was not there. Because we are officers of the court, okay? And we didn't do that. We did not insult your intelligence. And we don't intend to do it now. Officer Marconi's death was a horrendous death. Should have never happened, okay? But here we are. But just by way of comparison, I just want to because someone brought it up in the voir dire, you know, police officers are a protected party, you know, under the law. That's what makes it capital murder. But I'm going to just so you know, here he's, comparing him to Charles Manson, that if this morning a twice convicted murderer went to an HEB and a young mother was walking out of HEB with her 3 kids, and that man, that twice convicted murderer, a worse history than Mr. McKane, went up to her, and shot her twice in the head, the photos would be just as horrendous, if not worse. The suffering of the family would be the same as the Marconi family is going through, okay? But by way of comparison to that guy, the most we could do is give him life with parole. And what elevates this case is because Officer Marconi was a police officer. And so when they're pointing and saying he must die, keep that in mind. Keep that in mind as far as your humanity and the humanity of that individual. That at this time in Texas, the law happens to say that. That doesn't mean you have to do it. Okay? Now, on special issue number 1, we know that the burden of proof is on the state, and it's beyond a reasonable doubt. And, you know, it is what it is to you, but just so long as you know it's the highest burden in the law. Okay? And we know it says that the probability, and we talked about probability is not defined in this instance, you know. Probability is what it is to you. To one of you, because a human's life is on the line, it might be 90%. It doesn't need to be a percentage. It doesn't have to be more or less than not, or more probable than not. You can elevate that if you want to, because the stakes are so high. But that probability has to be beyond a reasonable doubt. And it has to say that the defendant would commit criminal acts of violence, continue to commit criminal acts of violence that would constitute a continuing threat to society. And the state went through those things, right? But they are terms of art, and they're there for a reason. Criminal acts of violence, it could be different things. They're citing the attack on the bailiff. But there's a further line, because otherwise we could stop there. There's a further line. Constitute a continuing threat to society. And we know the society includes prison society. But a continuing threat. And the question is, under the circumstances under which the assault on the bailiff occurred, is that a continuing or is that isolated? Okay? And once that happened, the first evidence that the state put on was the attack on that bailiff, right? The elbow. Dr. Crowder alluded to it because, listen, there was a case in Atlanta of a black gentleman on trial.
No, I don't object at this time to relevance.
No, it came out from Dr. Crowder. You've made an issue of that. And the
Jeff, I don't
FBI...
object to relevance.
Let me hear it.
The FBI behavioral scientists in that case told the prosecutors, go, instigate him, and that guy will react.
Judge, this is outside the record.
No, Dr. Crowder testified to that, Your Honor.
I'm going to allow a little more.
Okay.
based on
That's
the
as far as
testimony.
I'm going to go. I'm not trying. What I'm telling you, we've all known about that. I'm not saying, and I'm not questioning, I'm not saying that they knew about it or that they did it like that. I'm just telling you that it does happen, okay? I'm not saying these particular prosecutors did that with that mindset or that some guy came and told them. That's not what I'm saying, okay? But we do know that. Now, Mr. Fuchs went over some of these things, some of the events that Otis has in his life. And like he said, all of a sudden it becomes a 12-inch butcher knife and the like. And Latasha, who I think at the time would have been like 9, got scared because Ronnie and Otis were arguing over who ate the last hamburger. Now, I don't know. I don't believe that Otis and Ronnie and them lived in a 4,000 square foot home. Latasha calls the police because she's a child and she gets scared. And I don't know what the response time of the cops was. But I guarantee you, that kitchen couldn't have been very big. And Otis is an athlete. I submit to you, if he wanted to catch him, he would have caught up to him, and he would have cut him. He didn't. And when the prosecutors of the juvenile department got the case, they evaluated it, and you know what they did? 6 months probation. Just 6 months probation. And guess what? You heard no evidence that Otis violated it. You know, and I'll go through them, but the possession of cocaine, you know he went to Concho. I don't know how long he was locked up in Concho, but they could have brought you the records of the jail to see what the discipline issues were there. I don't know. The assault on Sahara, The prosecutors looked at it. They decided to give him 6 months deferred adjudication. Deferred adjudication means you don't even get convicted. It's probation again. That's how bad they thought it was. This office, their office, gave him 6 months deferred adjudication. Then you have the car argument. Like Mr. Fuchs said, it's like, look, they were going like 20 miles per hour. Obviously, the car stopped. In my head, I just don't know how Sahara, in that moment, would take out a phone, set it, find the app to record or whatever, and then start recording without him seeing. I just don't understand that. I don't know if maybe she was the passenger. I'm not too sure. I just don't know how someone does that without the other party noticing. So that's the only question I had on that issue. The McDonald's, okay, first of all, Otis had a right. From the orders, there's no question that he had a right to take that child or have that child delivered to his mother's residence and the like. And so I don't know what happens to a man when you're trying to see your kid and somehow the rules changed and now you've got to be here at a McDonald's and you can't go out into the parking lot with your own kid. He didn't hurt the kid. And then this idea that Mr. Paget Hill came and this young man who's tall and strong, and he put him in a headlock, and the child went back to Miss Paget Hill, and guess what? Mr. Paget Hill was not hurt. He wasn't punched out. He wasn't pushed to the ground or anything. And like he joked, he was a little bit younger then. He wasn't 72, and I get that. But I just want you to put it into context. Obviously, we have the capital murder, which I will tell you that no one deserves to die like that. Nobody. And then we have the assault on the bailiff. I just remember from seeing the video, there was an issue that's legal that is between the lawyers and the judge. And I saw the video, but when it happened, I did go like that. Like we wanted to talk to him after a verdict. You always do. And for how much of an aggravation that was, I couldn't tell you. But in his cross, in Mr. Lebrel's cross of Dr. Crowder, he was talking, it's escalating. And you see, because in this business, it's not a business, don't get me wrong, but in courts, especially in capital murders, what you have is guys that from when they were very young, they're in school, they're bullies, they're kicking the heck out of other kids, and then later on they catch them with a knife, and then later on they catch them with a gun, they're expelled, then they go and they rob a stop and go, later on they pistol whip a guy with a gun, later on they rape a woman, and then later on they commit a capital murder. And those are just guys that are pure evil from when they were young. They're just, man, and they keep getting worse and worse and worse and worse and worse. And that's the stair step that Dr. Crowder talked about. Really, it's a stair step. You see it when you see their lives. Otis is not that. Otis is not that. What Otis has, and if you look at this future danger thing, is, and you can tell, his mother testified, and she said, it was only 2 days out of the week. I don't know how much he was struggling. We don't attack moms. How many nights he was gone. Was she working? Was she somewhere else? We don't know. The fact of the matter is, Reggie told you, Otis would take care of his little sisters. Okay? And when you're that young, she said, apparently it started around middle school. You know what happens? You really don't have the coping skills. Males mature at the age of your frontal lobe, maybe 21, 20, 25, something like that. At 13, you're still developing. You don't have the cognitive skills. And so, that affects you, that this responsibility of being man of the house that a lot of minorities go through, and not only minorities. There's someone here from Wisconsin. I'm sure in Wisconsin the same thing happens, And so, but everything is evidence-based on this future danger issue. They have to prove it to you beyond a reasonable doubt. and they have to prove the probability to you, whatever amount of probability you want to give it. Now, what is the evidence? Okay, the state for sure, obviously the capital murder, and for sure they have harped on the assault on the officer, okay? Now, but what is really the evidence that they've had? Really, because when we came to trial, we all knew the evidence. You know what they've had is that when he was 13 years old and he got placed on probation, when he gets structure that he didn't have when he was a kid, okay? Because his mom is gone. But when you give him structure, he becomes compliant. You know, it's almost like a kid. You tell your kid, okay, bedtime at this hour, and then you wake them up at a certain hour, and then you gotta eat now. You even tell them, hey, have you gone to the restroom? You know, because kids, okay? And so some people need that structure. But we know that when he got that probation, and it wasn't for aggravated assault, it was a deadly conduct, it was a misdemeanor. When he was 13 years old, he complied. You know, the arrest for the capital murder. When we try capital murders, a lot of times, the state, you know, they brought one classification officer, that young lady, right, that talked about that Otis said, I think stupid bitch or something like that. I don't remember now. But no, they bring you 1, 2, 3, 4, 5.
To other capital murder cases, Your Honor.
No,
It's
no.
not relevant. There's no evidence.
I'm talking about the lack of evidence, Your Honor. I'm entitled to argue that. They don't have that.
Excuse me, Judge, I've asked for a ruling, please.
He can argue that.
Yes, it's the lack of evidence. Because if they had discipline issues with Otis, they would have brought you, he sent a note to a guy, hey, let's escape. Hey, get me a shank. They would have caught him with a shank, you know. They would have seen him spit at another guy. They would have seen him break lights. You know, even in the unit, what, you think he couldn't have been disruptive? He said it on the deal. If I wanted to, I could break that light. Did he? Could he bang pants and keep the other inmates awake and cause problems? Could he say stupid bitch not only once, but 50 times? He could have been disruptive even in that unit. But I think it's disingenuous. And basically say, he was locked up 23 hours a day, but for that, man, he would have done this. No. They told you when we were on voir dire, the answers to these issues are evidence-based. The fact that they don't have it, the lack of evidence, they can't make it evidence. You know, you see what I'm saying? 5 years. I don't want to cuss, but a bad dude, he can't be good. He can't just say, I'm going to turn the switch on and be good now. That doesn't happen. A guy that's bad out here is going to go in there and he's going to be bad in there. And they don't have it. And they know they don't have it. Even in that unit, they don't have it. Not to mention that he gets attorney visits. You saw there's medical records that would continuously bring him down for medical questions. And what, you think that it's in the 23-hour Bravo Juliet unit? No, it's not. They bring you down and you're in the medical, and the medical is like offices. There's other guys there that have issues. Not one incident. Not one incident. When this guy gets structure, he behaves. Okay? When we were picking the jury, because of the COVID, we were picking it in the jury room. Look, I don't know if we were in trial, picking the jury 60 days maybe. But just think about the times that he is able to do something. Because he has to be transported. Then they bring him in the morning to court, to the jury room. Then we take a morning break. They walk him over here to the restroom or to have a drink. They walk him back. Then lunch. They walk him to lunch. Then after lunch, they walk him back. Then we take the afternoon break. He leaves with the bailiffs. He comes back from the break with the bailiffs. And then finally, he leaves at night with the bailiffs. And then they take him over there. That's 10 exposures per day that he had with 2 bailiffs walking beside him like this. Okay? Nothing. The opportunity has been there. And all they can bring you that for 5 years is that this guy follows and becomes compliant when you give him structure. Yeah, you're right. Out here, He doesn't have coping skills. He gets stressed out. He gets emotional. That deal about getting angry and crying, going into a room and cussing or talking to himself. But when you give him structure, much like a child, he complies. And that's the best evidence that you have, that if you give him life without parole, this guy's going to behave in prison. Now, the events that he has had of violence, yes, they are the rocky relationship, the event with Ronnie. They're like situational, like Dr. Crowder mentioned. You know, I don't condone the elbow to the officer, but I would submit to you that that situation of getting convicted of capital murder is never going to come up in his life again. He's never going to have to deal with Sahara anymore again. He's never going to have custody issues again. You see? He's never going to have money problems again. He's going to have a roof over his head. You know, I don't think any of you ever said, because there were some people said, oh man, we don't want to pay for him to be in prison. You know, none of you, otherwise you wouldn't be qualified. But, you know, I don't think that's consideration. But once you give him the structure, this guy's compliant. And it doesn't have anything to do with the Bravo, Juliet. And then they brought you that classification guy from TDC saying, oh, you know, they keep doing this like, oh, there's one guard unarmed with 144. You know, he makes it look like we all should want to go to prison because it's such a party. You know, it's not. You go to prison, there's structure. You misbehave, boom, you go to segregation right off the bat. You lose commissary. Remember when we asked someone, you know, is commissary very important to prisoners? It's like your little bank, you know. You're trying to buy gum or cigarettes or whatever. You know, that's important. You misbehave in prison, you start losing your commissary, you start losing visitation rights, and they put you in segregation. Okay, there's a lot of things they can do, and they can make your life hard. Okay? They can't show you beyond the reasonable doubt and the probability that in prison, long term, this guy's not going to be compliant. If anything, the evidence shows you that once he gets structured, this guy is compliant. Now, we talked also at Bordier, and I'm bringing this up because Mario mentioned Charles Manson, that the Supreme Court has said that the death penalty is for the worst of the worst. And we talked about Bordier with some of you. Ted Bundy, raping, maiming, and killing women. I think it was like 30 women, you know. The guy in Michigan that was burying his little kids in his backyard. They found like, I don't know, 16 or 40 kids, you know. The guys from 90...
This is outside the record. This
No.
is not evidence.
Your Honor, it's a reasonable deduction from the evidence. And the Supreme Court has said that the death penalty is reserved for the worst of the worst. And they make their argument. Let me make my argument.
The state made that kind of a comparison. I'll let the defense do the same.
You see? And because the Supreme Court has said, and look at that. Look at the comparison I said earlier about the lady at the HEB, this young mother that gets killed. We can't do anything to that guy. And now Otis is worse than that guy because it's an officer. Is that really what we're going to do as a society? Now, we brought you Dr. Crowder. And, you know, they're harping on, oh, my God, he didn't see this video, he didn't see this video. Let me tell you what. Most crimes don't occur on camera. That's why this was such a stupid crime to do it in front of the police department. It has cameras everywhere, okay? But these guys, both he, Fabian, Clem, and our other doctor, Dr. Mercado, they always make conclusions and reach conclusions based on police reports. Why? Because most crimes don't occur on video. You don't need the video so long as you have the reports. Okay? Now, he told you, and let me back up because the state came first. You know, on July the 12th, they bring on Dr. Arambula to this case. We were already starting the trial. I don't know what light bulb lit up in their head, go, oh, shit, we need some guy to come and say he's a future danger. you know? And they picked this guy, Arambula, who his ethics, not much different than, he's an MD, you see? So none of us could call our doctor and say, hey, you know, I got a headache and my chest is kind of hurting. Can you give me some medicines? Because, I'm telling you what went on. They're not going to give you anything. They're not going to tell you a diagnosis over the phone. They say, every doctor say, you need to come in. Even sometimes refills, when you get a refill and it's too much has passed and you haven't been in, they go, no, you got to come in. We got to check you out. Because it's unethical. It's unethical to give an opinion when you haven't spoken to the guy, to the patient. And remember, they just brought him in July the 12th. Now, he comes in and he comes up with this diagnosis of antisocial personality disorder. Okay? Remember, unethically and without talking to the patient. And they're checking off boxes, right? Well, we put on our expert when Dr. Crowder was testifying. Okay, behind Mr. Del Prado was, I think, Dr. Fabian, and over there on the left-hand side was Dr. Arambula and Dr. Clem. Okay? Dr. Arambula heard me calling him out. Okay. Now, he's called down for acting unethical. Someone says something about me that I'm unethical, I'm going to come back and clear my name and defend myself. Arambula didn't come back. They didn't call him back to say, hey, I didn't act unethically. My judgment is sound. You know why? Because it's unethical. And he knows it. And he didn't think we were going to catch on. And the reason it's unethical is to do that is unreliable. It's unreliable. Now, let's take it now to Dr. Crowder. What does Dr. Crowder tell you? And Mr. El Prado says, he wanted to focus on the research. There's research for a reason. It's because those researchers are looking at what happens, like what Mr. Del Prado is doing, what prosecutors do. He's a bad guy, and he did this, and he's going to kill, he's going to do this, he's going to do that. Well, they did. They went, and that study was for 1 year. And he told Dr. Crowder, you didn't tell the jury that it was for 1 year. Well, ask him, and he'll tell you. It's very simple. This is a question and answer kind of thing. They did this study when guys were coming in, and they were checking them out for antisocial personality disorder to see how they would behave. And they compared them to the guys that didn't have it. Well, at the end of the day, and it was a 1 year study, okay? At the end of the day, neither group was worse. No one had more disciplinary issues than the other. And so they said, look, it looks like it's a non-predictor. That's what we're saying. It's a non-predictor. The other study, the post-Furman study, and the reason they said the case came out in 72, the Supreme Court said the death penalty as it's being applied is unconstitutional. So all these guys that had death penalty, a lot of things changed, right? Now, they followed them. This is a real life human study. And they checked everything about them. And you know what? All these guys, that juries such as yourselves, that prosecutors such as these, had convinced people these guys are going to be a future danger because they have this anti-personal disorder or whatever. You know what they found? It wasn't true. It wasn't true. What they found is that the majority of these guys were compliant. In prison, even after being released, most of them, almost 90%, if not more, were compliant. They weren't future danger. So to get the 5% that kill later, I'm not saying it never happens, to get the other 5% that maybe were going to be rowdy in prison, to try and get those guys, and let's kill those guys. I think the statistics, we have to kill like 167 to get 2 that are really going to kill again. We have to kill another 167 guys that were never going to be a future danger. And that's just reality. And that's what Dr. Crowder was saying, that for Dr. Arambula, who never examined Otis, who acted unethically, who the state did not call back to defend himself, to come in here to a court of law and under oath tell you that this guy was going to be a future danger, that's a disgrace when a life is on the line. Let's go further on this future danger issue. They have, I guess the only two people that think or fell for this antisocial or that told you anything about antisocial personality disorder was Dr. Arambila and Mr. Del Prado, who's not even a doctor. But he thinks if you check off those 7 things, oh, you're an antisocial personality disorder. And then whichever other disorder he was talking about, oh, there were 3 there, he's got that one. Well, so what? The research shows they are not accurate predictors. They are faulty predictors. As a matter of fact, they don't have any quality for predicting it. Even if you were to believe it, because I suggest to you that it's not believable, it's not credible. Because if it was credible, they would have called Dr. Arambila back to defend himself. Now, worse, their own doctor, Dr. Fabian, he was the state doctor. He's a psychiatrist like Dr. Crowder. He found the same disorder, basically, cannabis abuse disorder. Their own doctor. Why didn't they call him? Why do they hide him from you? They could have called him and they could have said, hey, what did you find? Did you find antisocial personality disorder? He would have said no. They didn't bring him because it knocks the heck out of their future danger argument. Dr. Clem, who did some tests, nothing about antisocial personality disorder. He scored a little bit high on an MPI. They didn't call their own 2 doctors, man. Think about that on this future danger. I submit to you that when you read that special issue and you really apply the beyond the reasonable doubt, and remember, at guilt innocence, I did not come to argue to you anything that I didn't believe was reasonable. When you look at beyond the reasonable doubt on this probability, whatever probability you want to give it, we know it's going to be more probable than not, but you could say to me it's higher because a life is on the line, and I don't find it. And I submit to you that all of you should answer that the incidents that he's had, even when he was 13 years old, have been isolated. And with regards to the murder of Officer Marconi, look, there were a lot of things going on with this guy. And the coping skills I'm talking to you about, that he doesn't have them, this child custody and being denied, and we know that there's some 911 calls where he would call. We know he was trying to see the kid at the McDonald's. Reggie said that he was trying to see him. He was constantly crying and getting depressed, and he couldn't handle it. And rightfully, wrongfully, for sure wrongfully, he blamed the police. And I assure you, it wasn't like 2 times 911. How many times does a father go, you're going to go pick up the child? Hey, no, you're not going to take him this weekend. I saw you with a woman or whatever. And you don't call the cops every time. If a guy called the cops every time there's a custody issue, it doesn't happen. Parents that are divorced have visitation, pickup, and drop-off issues all the time when cops don't get involved. So there were more times, way more times, that was happening. And he's using cannabis, and he says, oh, well, only the family told you that. No, you know he's buying and selling. You don't buy cannabis in nickel and dime amounts to sell again. You buy it to smoke it. And Reggie told you that he was doing that K2 and that spice. Not only the cannabis, and then he was also doing it with that strong cannabis, marijuana. Because I hadn't heard this phrases, but perp, they said, an exotic or high THC content cannabis. And he was abusing it during that period of time. Probably trying, to self-medicate or whatever you want to call it. And he didn't handle it. And he erroneously blamed it on the police because Sahara's mom worked. Now we know she worked as a Bexar County Sheriff. He thought it was with the cops, with the SAPD. And then he just lost it. And that kind of situation is never going to arise again. you know, if you give him life without parole. That's just not going to. You think Sahara wouldn't let him see the child out here? You think she's going to take him over there? That's over. All those situations are over. And all those lack of mechanisms, that coping skills that he doesn't have, they're going to go away in prison. I'm not telling you that prison is not going to be stressful, but it ain't going to be the cakewalk that Mr. Del Prado thinks it is. He said it is. With regards to mitigation, again, I submit to you that the 12 of you or 10 of you should say there is not a probability of future danger. It's just not. The evidence that you have is the 5 years with one incident, and the prior times he's been on supervision without violations. You stupid bitch. That's it. Even at the Bravo Juliet unit. Now, if for any reason you all feel that he is a future danger, okay, then you go to the second special issue. Now, the second special issue has no burden of proof. Okay. Remember when the prosecutors at that PowerPoint that Bordar would say, "Oh well, first you have to ask yourself, is it sufficient?" And then you have to ask yourself, "Is it true?" And then you don't have to do any of that. That's not the law. Nowhere in the law does it say you have to do that. They like it because it kind of creates a burden, you know. But the law and the Supreme Court have said this issue has no burden at all. It could be anything to you. And it says, taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, his personal moral culpability, is there a sufficient mitigating circumstance? It could be one thing. It could be one thing. Or sufficient mitigating circumstances that you feel like, I don't want to kill this guy. Okay? It's sufficient for me. That's all you have to say. It's enough for me. So for me, it's mitigating. I believe it. I'm not going to kill this guy. And that's it. You don't have to go through this rigmarole that they talk about. And I submit to you, we brought you those maps just because I don't know that we all know it. I mean, I can't tell you specifically that I knew that. I generally know that the east side is impoverished, okay? But I don't really know statistically. And what do we find? You know, there's a lot of single moms, a lot of single parent households, a lot of a lot of key lock kids where they get home and they come home with the key. The kids come home from school, mom's not home, and they have to say, you know, do for themselves. And I understand what Mr. Del Prado said, or someone said. It's like, hey, but not all of those kids turn out to be murderers. I understand that. I understand that. But like someone told me one time, we're not all born with the same amount of rebar in our foundation. You could have a brother in the same family that grows up real strong, and you could have a brother in that family that doesn't have the same foundation. Okay? I brought you Sandra McKane. It got a little bit out of hand at the end, but just to show you that she struggled. She struggled. I mean, you know, working at a nightclub, you know, then Jack in the Box, then McDonald's. It's like, that's an unstable, you know, I mean, all of us know that. You know, who wants to live like that? Jumping from fast food place to a restaurant to stuff like that. You know, it's someone trying to make it, you know, and then it takes a toll on the kids. Because even she said, no, she downplayed it maybe. I'm not too sure that it was only twice a week or whatever. But I don't know. You know, everyone's got to have a social life too, and I don't blame her. But yet, here's Otis having to care for his two sisters, and he did. We brought you Reggie, who Reggie said, man, you know, I've known him since this time. He was a fun guy. He was joyous. You know, he has that in him. This isn't one of those guys that is born evil. You know, he said he was a fun guy, good athlete, had dreams, a little bit maybe, I don't know, some grandiose ideas of playing in the NBA and stuff like that. Breaking into the NBA, it's extremely difficult. He thinks he's the best basketball player ever. You know, more power to him. But Reggie also told you one thing. He told you, and it was confirmed, that he felt that he saved his life by opening his doors and his mother too, because he was in a bad place. Reggie was. He said he literally saved my life. You know. Reggie told you that, confirmed that he was having custody issues with Sahara, and he told you he was smoking K2 and Spice, and that guy has 2 businesses. He's a good guy. He has his family. He's married. He had no reason to come in here and lie to you. And then we brought you Jeremiah. And Jeremiah's a young boy, and he loves his brother. And Otis, we know through the calls, is teaching him, don't do what I did. Don't do what I did. Get good grades in science. Get good grades in math. Stay out of gangs. Stay out of trouble. Because we know that Otis was not a gangbanger when he was younger. He was an athlete. In high school you have the jocks and then you have the gangbangers. He was a jock. And so you have things that are mitigating in this case. Coach Burdick came in and said he had the most beautiful smile. He had the great smile. He was a great guy in high school. He was a good athlete. He had some skills to maybe go to the D League. And he told you what Coach Peel told him. He said, remember he got mad that another football player told him something, and he said, my job is to save them all. And he took on that philosophy of Coach Peel. And of course we brought you Dr. Crowder. And I've already talked about that, I think it's mitigating that there's evidence out there, research that this guy's not, I don't know, there's mitigating circumstances. Dr. Burdick confirmed that there was a shooting. You see, these are jocks, right? So they're going to get that hamburger, whatever they did. Some gangbangers come and throw some rocks. Okay, hey, what's going on? Guns? These guys weren't used to guns. They take off. They go back, the car's all shut up, That wasn't their lifestyle. And the proof is this. Look, it's bad, but he's 31 at the time of killing on Officer Marconi, okay? He doesn't know about guns. He has to Google about guns. A gangbanger at 15 knows about disassembling a Glock. At 31, this guy doesn't know jack about guns because he's researching it on September something of 2016. In that shooting, they both confirmed that he saved LJ. When they were being shot at, he grabbed LJ and he ran. And so maybe LJ is grateful for that today. I will tell you that in 2016, it came out briefly, there were a lot of things going on between police and the black community. And I don't know if it was with consciousness. I don't know. I'm Hispanic. I'm not black, but I don't know what was going in the black community. We all know there were things going on. There were police shootings of black young men. And the cops knew it, so the black community knew it. They put the police departments on lockdown. They doubled up all the cops because they knew the suspect was black. If the police knew it, if the police know it, the black community knows there's tensions. Maybe I didn't know it. Again, I'm not black, but there were things going on, and maybe that was part of it, maybe not. This again against the system. Okay, look. In the end, and the state might make what's called a plea to law enforcement for the community. Where they're saying, "Oh, keep us safe. Please send a message to the community. If you kill a cop, you're going to get the death penalty and the like." I would say to you that the message that maybe you should send is like in this particular instance, the evidence is not there, and not get caught up in this public opinion. What's the public going to think of you if you don't give this guy the death penalty? The law presumes life, okay? Otherwise, the state wouldn't have a burden.
That is a misstatement of the law.
The state has the burden of proof.
Please.
All right, I'll sustain.
The state has the burden of proof on special issue number 1, okay? Look, the Supreme Court has said, and some of you were told, it's a personal, moral decision on this special issue number 2. Whatever is mitigating to you, whether you want to leave him alive for Jeremiah, Whether you think, man, he's not escalating in crime, I don't think he's going to be a bad guy. If you say, man, this research, I didn't know it, that we're killing young black men, and then they're really not dangerous, for whatever reason that you think, without any measure, okay? I submit to you that there's sufficient mitigation to answer this question such that he gets life without parole. And again, we're not asking you to let him go, okay? And life without parole, one way or the other, he's going to come out in a coffin, okay? But I would say to you that as a society, and I mean this with all due respect, and I mean it, can we please stop killing young black men? You know, really. I think it's time. We've had enough death in 2020, man. You know, maybe we ought to stop. Thank you very much.
All right, members of the jury, I'm going to give you a short break. Let's give it a few minutes, and then we'll come back and do a closing argument.
All right, for the jury.
no, nothing yet. We haven't gone on the record yet.
Okay.
Wait,
We
no.
have conferred with our client, and we do not intend to call him.
That needs to be put on the record in front of the jury. Yes.
In 17 CR 1505, State of Texas versus Otis McKane. Present in the courtroom or for the state?
Sure. Tamara Strouch, Mario Del Prado, Jessica Schultz, Nathan Mooring for the state.
Defense?
Raymond Fuchs, Joel Perez, Danny De La Garza, and the defendant Otis McKane, Your Honor.
All right, now for the benefit of the record, during the middle of the defense closing argument, the defendant stood up, indicated he wanted to speak to the court, made a reference that he desired to testify. Since that time, on the break, the attorneys gathered with the court in chambers. We discussed the issue. We came back out. Defense, have you had an opportunity since the break began to specifically consult and discuss that issue with your client?
Yes, Your Honor. We've spoken to our client, and he is not going to testify.
All right. Are you requesting to reopen the evidence at this time?
No, Your Honor.
Is there anything else you want to put on the record?
No, Your Honor.
State, are you requesting to open your part of the evidence at this time?
No, Your Honor.
All right. Let's go ahead and bring in the jury.
Judge, may we approach?
Sure.
Okay.
You may be seated.
All right, welcome back, members of the jury. Now, just to make sure the record is clear, during the break, a few of you asked the bailiff to ask me some questions related to the testimony, and the response of the bailiff to make sure to tell y'all is that the court cannot communicate with you at this time. And so that is going to continue. I cannot communicate with you about anything as it relates to what is happening. You are the judges in this case. You have all the facts that you use to make the determinations you need to make, and you have all the law through the court's charge. All right. So where we last left off, State, you are in the middle of your closing?
Yes, sir. May we approach?
Yes.
for the defense. Ladies and gentlemen of the jury, Mr. Pettis ended his closing argument telling you that you should not vote in such a way that this defendant receives the death penalty because of the color of his skin. There is nowhere in this charge, in this law, that mentions race. There is nowhere in this charge that says that a person based on the color of their skin should not be held accountable for their actions. There is nowhere in this charge that says, based on the color of someone's skin, that you should not follow the evidence and render a true verdict according to the law and the evidence. Ladies and gentlemen of the jury, justice is blind. And it needs to be blind so that everyone, regardless of the color of their skin, regardless, gets a fair trial. And we know that 12 of you have given this defendant a fair trial. You have heard all of the evidence. This defendant has received a fair trial. We've presented witness after witness. We've had hearings after hearings. The judge has made rulings as to what evidence you can hear and you can consider. And we've been doing this for 4 weeks. And there's nothing in here that mentions the defendant's race. Or the victim's race, for that matter. Nothing. Because that's not evidence. And let's talk about the evidence in this case. Long last year and early this spring when y'all were being selected, each and every one of you told us under oath, you took an oath to tell the truth. And each and every one of you told us that based on the law and the evidence, that you will a true verdict render according to the law and the evidence. Every single one of you told us that. And we know this is not an easy decision. We know that. But all of you, every single one of you, told us that you can vote in such a way that the defendant, this defendant, it wasn't a hypothetical defendant, it's this defendant, Otis McKane, receives the death penalty based on the law and the evidence. Every single one of you, under oath, told us that. And now, the oath that you took when you started this case, before you heard any testimony, was the oath to follow the law. And we're asking that you do that. That you don't set the law aside and the evidence aside and base your decision solely based on this defendant's color of his skin, as Mr. Pettis would like you to do. Justice is blind, and it needs to be blind. It needs to be based on what this defendant's actions are. Special issue number 1, the first question that you'll consider: is there a probability the defendant would commit criminal acts of violence that would constitute a continuing threat to society? You heard overwhelming evidence that this defendant is a future danger. The word would refers to a future event that may occur under specific conditions. And the defense kept talking about this situational, and they kept calling it incidents. The capital murder incident, the assault on the deputy incident, the butcher knife to his cousin, threatening to cut him incident. But they're all conditions that existed for this defendant that caused him to commit those acts. And what's so important for you to remember, these are choices. These are all choices that Otis McKane made. They're choices. His decisions, his actions, his choice. We're here today, and for the last 4 weeks in this courtroom, because of what the defendant chose to do. No one forced him to do anything. You didn't hear evidence that this was the capital murder itself was something that someone forced him to do, he was threatened to do, that he had a minor role in it. You didn't hear any evidence of that because it didn't happen. This was his choice, his desire to carry out the capital murder, to shoot Detective Marconi twice in the head. And what do we know? You've heard about this, you've seen this video. But as the verdict's being read, and watch it, I'm playing it again so you can see it. This is the evidence. It's evidence for you to consider about this defendant's future danger. And the testimony you heard was that he takes his tie off, he's unbuttoning his shirt, he unbuttoned his cuffs, untucking his shirt. He's getting ready to fight. And there's no, watch the lawyers. I don't see the lawyer doing his hand. Danny De La Garza's lawyer's right there. He's right next to him. We approach the bench on a legal issue, but watch. And what do we know? Deputy Gonzalez is telling him, McKane, please get up. McKane, get up. He's not raising his voice. The defendant's not looking at his lawyer. He's talking to Deputy Gonzalez. And finally he gets his handcuffs out to say, come on, let's go. And watch what he does. There's no evidence. This is who this man is. You heard him. You know, what we are bringing you, ladies and gentlemen of the jury, we're bringing you not just testimony, because then the defense could just say, you know, oh, you can't believe Zaharia, right? You can't believe her. She's got an agenda. She didn't, you know, they've got issues. We're bringing you evidence of exactly what he said to her. His threatening nature. And she told you over and over on the stand that he threatened to kill her on multiple times. And you're hearing it. You're hearing his own voice threatening to kill her. And she told you it happened multiple times. And back to the assault on the deputy, the defense counsel said that it was provoked, that Mr. Del Prado provoked it. Well, Mr. Del Prado finished speaking about 2.5 hours before he attacked that bailiff. Mr. Del Prado finished speaking. Mr. De La Garza spoke. Mr. Pettis spoke. I spoke. So that's about 2 hours right there. And then you'll deliberate it just under 30 minutes. And he provoked. And he's saying he was provoked. The situational provocation. He wasn't provoked. This defendant does what he wants to do. It's a choice. When do we move away from blaming other people? The entire defense argument is, let's blame Sahara. Let's blame his family. Let's blame everyone else but Otis McKane. He's here because what he has chosen to do, his choices, his actions. And do you think for 1 minute that Saharia wanted to come in here and relive that part of her life? The part of her life where this defendant beat her, and she talked about the bruises, and where he tried to choke her on several occasions, and she specifically, and we know it's true, besides these, he went to jail for 60 days and was convicted of the offense of assault family violence on her too. So it's not just her words. We're bringing you evidence besides that corroborates what she's telling you. We're bringing you the tape, we're bringing you her testimony, and we brought you the judgment where he was convicted of it. And he goes on, this thing, and when you listen to this, and you have all this back there to look at, to listen to, I guess back here, to look at and to listen to. And you can play it, you can hear it, but what you heard in this, you can hear the car screeching. They tried to minimize it, and that's their job. Their job is to minimize it. But what's going on in that car was a horrifying experience for Sahara. With her baby in the back seat, and he's grabbing the wheel and he's yelling, "I'll kill you. Son of a bitch, get your bitch ass hoe, get your bitch ass," and he's yelling at her. That was horrifying, and you heard it, and you heard his tone. And this is the Otis McKane that's in front of you. And he goes on. This is him. This is the defendant when he gets angry, when he gets agitated. You heard it. He's calling her names, he's degrading. And then she told you the other incidents where he grabbed her wig on several occasions and threw it in the dumpster. For what? To humiliate her. To make her embarrassed. And that's who he is. Otis McKane does what Otis McKane wants to do. And you've seen this throughout this entire trial. And every piece of evidence we brought you, and every statement that you've heard from this man's mouth. In this first question, the law says you can find that the defendant would be a continuing threat to society based on the capital murder itself.
You object on this misstatement of the law.
You can rephrase it.
That's the law. The law is that based on the facts of the capital murder itself, the jury can find beyond a reasonable doubt that there is a probability that this defendant would commit criminal acts of violence that would constitute a continuing threat to
We
society.
object again, Your Honor. It's a misstatement of the law under Dankins v. State.
That's absolutely the law, Your Honor.
Overruled.
It's the law. Okay. And we talked to you a lot about that, actually, in voir dire, in jury selection. And they were there. And it's the law. And you can do that based on this. And both defense attorneys and everyone in this courtroom would agree that this is the most heinous, evil act that you had to witness, that he committed. And so let's look at the offense. And I'm sorry you have to watch this again, but this is why you're here. This is what the defendant did. Detective Marconi was working that day. He pulled over Ricky Martinez. He was doing his job. And this defendant targeted him because of his uniform. Because he was wearing a San Antonio Police Department uniform. And he feels justified. Justified in what he did because the system wronged him. Remember how when you first saw this? And don't ever lose that feeling that you had when you first saw this video. How shocking, how horrendous, how unspeakable it is. And he doesn't shoot him just once. Once wasn't enough. He shot him first. And we know he was alive by Dr. Simon. We know he was alive. He was shot. And he wasn't finished, right? Criminal acts of violence, well, that's two right there. The first shot and the second shot. But he wasn't done. He kept going, right? He had to make sure he finished them off. I mean, you saw that. And I hope you still have that feeling of when you first saw it. I mean, I hope you're not numb to watching this video. But that's what Ben Marconi went through at the hands of this defendant. And what do we know? His criminal history started when he was 13 years old. And it was his mother. The defense said, oh, we don't know if it's a 12-inch knife. His mother said it was. When she got home, the police were still there. His sister Latasha was in fear. And she called the police. It wasn't some joke that was going on between the defendant and the cousin. She was scared. And the defendant's saying, I'm going to cut him. He wouldn't let go of the knife. The deputies had to take it away from him. And he went to juvenile court and got placed on probation for that threat, terroristic threat of his cousin Ronnie. And it was anger management, and he had to go to a victim impact panel. You know, his mom said he didn't go to the classes. But that's what he was ordered to do. And then we know in 2006, he's caught with drugs, cocaine in Concho County. He does probation. And he gets thrown out of drug rehab, right? For not following the rules because he can't. He chooses not to. These are all choices that he makes. The 2012 assault. And remember that Sahara told you that they were at Walmart? And he starts counting down. They're sitting in the car. She's in the driver's seat. 5, 4, 3, 2, 1. And she knew she had to get out, right? What would happen if she's stuck in that car and she can't get anywhere? She gets out because she's in fear. And she's in fear because of what he has done to her before. And what does he do? She's right in getting out, right? Like the thing that you heard, that tape is from a different day when he tries to grab the wheel and run him off the road. But she's right. I mean, right? She makes the right decision because he gets out and he chases her down. He grabs her by the throat. He punches her. She has bruises. And that's the case that he pleads to and gets a family violence conviction out. And what does she tell you? She tells you in her testimony that there were red flags early in the relationship. I should have picked up on them, but I didn't. She talks about the abuse at this defendant's hands. No woman should ever have to go through that. Ever. And this is a big guy. He's a strong guy. And he beat her. He choked her. He left bruises on her. Because he does what he wants to do. And she said, do you remember specifically her testimony when she said, if I don't do what he wanted me to do, he would get enraged. Those are her words. And you heard that yourself on those 2 recordings. The other thing she said, if things don't go his way, he gets enraged. And we saw that. We saw that in court, right? Things didn't go his way. He didn't like your verdict. And he became enraged. And he took it out on someone who was not provoking him in any way, who was asking him to get up and let's go in a calm voice. And you saw that. He does the elbow and then he follows it up with a punch. That's future danger. Everything I'm telling you about is future danger. We know he sold drugs, but look at this. You have this whole stack right here of these text messages. You can look at it, every single one. He's selling drugs. Every time he's selling drugs in here is a criminal offense. It's illegal acts. He's providing drugs to people in the Lincoln courts in San Antonio. But he wants to do it. He chooses to do it. Right? Because these are his choices. He's making money. He's not paying child support. He's not supporting his son that he is now blamed. He committed the capital murder because he wants to see his son. He's making all this money, $1,200 a month at one point, and not paying for a son. But committing criminal offense after criminal offense. And we don't know. I mean, are they young kids, teenagers? I mean, who is he giving these drugs to? Doesn't matter, right? As long as he's making his cash. He's making money from this. And we heard from Jay Crowder, their expert. And I think it's, he really dismissed it, and the defense has too. But he dismissed the fact that he didn't watch the videos. He didn't watch the video of the defendant coming into police headquarters that morning, driving around several times. He didn't watch the video of the parapet video, the overhead one, where the defendant pulls up. He makes the U-turn. He pulls up behind Detective Marconi and gets out and shoots him twice in the head, gets back in his car, and busts through the traffic arms. He doesn't watch the video of the interior Coban video where this defendant puts his hand in and pulls the trigger as the gun is at the back, touching close range Detective Marconi's head, and blows his brains out, execution style. He didn't watch that. He didn't watch the video at the defendant ditching the car on Poplar, but he read reports, right? There's no report on that. He didn't watch the video of the Econo Lodge of Christian Fields and her daughter entering the hotel at 6:20. He never watched the video of the next day when he's down here getting married. He never watched the video of Christian Fields' interview with Detective Duke. He never watched that, right? But that's not important because he has some reports, right? And he says he never interviewed Sahara Palin Hill or her family. He only interviewed the defendant, his mother, and his 2 sisters. And we talked about, in jury selection, witnesses. right? Witnesses, and whether or not someone has like a bias. And clearly his family has a bias for him, clearly, right? Like what family doesn't? Sure. And the defendant is going to relay whatever information to Dr. Crowder that helps him. But he chose not to look at these other videos or this other information that could possibly help him make that determination that he testified to. And he talks about these 3 studies. And he gives 3 out of, I don't know how many studies there are, but don't you think the studies, what's important about studies are who wrote them, whether or not what their angle was? These could be individuals that are against the death penalty, right?
Objection, Your Honor, that's not an evidence. If they had evidence of that, they should have brought their own expert that they chose not to bring to say that these studies were not valid. So that's not a reasonable deduction of the evidence, Your Honor.
Overruled.
So he's looking at these 3 studies, one of them I think from 1972, and he doesn't say that, they only looked at what occurred, the recidivism rate after a year that they've been released. Right? And think about this, the recidivism rate that they're able to document is only when someone gets caught and arrested. If they commit a crime and they're not caught, or arrested, or charged and convicted, then it can't be part of their results. If they get away with it, just like Otis tried to get away with this capital murder, right? He didn't stay around. He didn't do anything to help Detective Marconi. He took off. He got rid of his car. About a mile from his house, he got rid of the gun, his clothing. He went to the Econo Lodge. All that shows flight, evidence of guilt. Gets married. But none of that would have been in that study if Otis would have gotten away. So the studies do not necessarily accurately portray what's happening, what's occurring. And he never interviewed any of the witnesses that saw the defendant commit the capital murder. And what's important about that is he's here saying that the defendant's not a future danger. He wants you to believe that. But the evidence shows otherwise. And do you think if he interviewed any of the witnesses that saw this defendant shoot Detective Marconi twice in the head, that there would be a single one that would say he's not a future danger? Do you think there would be? Think about the testimony. Jennifer and her daughter, Alexandria Patterson, do you think they would say that he's not a future danger? Mike Flores, who pulled up behind the defendant, and he's the one who had stopped in the red car across the median and saw him shoot Detective Marconi. Do you think Mike Flores would say that this man is not a future danger? Juan Enciso, the Via bus driver, do you think he would say he's not a future danger? Mark Bissett, who ran across the street, and he's the Army Special Forces, who attended and tried to save Detective Marconi's life. Do you think he would say that the defendant's not a future danger? Do you think any police officer that came to the scene to help save Detective Marconi's life and saw firsthand the shell casings, the blood in his patrol car, the blood on the street, do you think any of them would say that this man's not a future danger? What about Benjamin Marconi? If he was here, what do you think he would tell you? You know what he would tell you. He's a future
Your
danger.
Honor, that's not even a reasonable deduction of the evidence, Your Honor.
Well, look at his actions. Look at his actions towards Detective Marconi. The evidence shows overwhelmingly that he's a future danger.
When you put a bowl of acid in a round of paintball, this bowl of acid has to adjust its priorities from breaking down everything around it to thinking like a human so it can survive along with others. I am an acid that tries to survive amongst others and has learned to adjust to others. For some reason, that adjustment does not get placed back in my position to where I can continue to do what I do as a human. And it makes me resort back to being acid.
And we brought you Steve Bryant from TDCJ, the coordinator. So you know what happens when someone receives life without parole versus the death penalty. And what's the importance and the significance of that? The significance is, so you know if you answer the questions in such a way that this defendant receives life without parole, he will come in at that G3 status. He will have access to the common areas, the dining hall, classes. He'll be with classes with up to 100 people, 100 other inmates, church services. He'll have access to from 6 a.m. to 10 p.m. in the day room. He can go outside, play, what do they say, basketball, softball, where he's around other inmates, and it's one guard to 144 inmates. An unarmed guard who could be a female. And this is, look who, it's this man right here. This man who pulled a gun and shot it twice on Detective Marconi, execution style, cold-blooded. And he'll have a cellmate. And the cellmate could be someone who's there on a drug case, a DWI third, a non-violent offense. And the defense said to you, well, you know, and he's behaved these last, 4.5 years waiting for trial. And Mercedes Owens, Sergeant Owens came in here and told you he doesn't have the opportunity to interact with other inmates or guards. He's escorted he's escorted by these guards wherever he goes. They take one inmate out at a time, and he is in the most restrictive area at the Bexar County Jail, the maximum security area at the Bexar County Jail. He doesn't have the opportunity. But when he had the opportunity here in court, he attacked the bailiff. He's a future danger, and we have proved it to you beyond a reasonable doubt. The answer to special issue number 1, a true verdict under the law and the evidence, is yes. Is there any other answer that you can give to this, knowing everything that you've seen? It's your decision, ladies and gentlemen of the jury, but you have the power to protect the other inmates, the guards, the civilians, anybody else that this man's going to come into contact with at TDC, based on your decision today. And special issue number 2. Taking all the evidence into consideration, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, is there a sufficient mitigating circumstance or circumstances to warrant a sentence of life rather than death? And we put this definition up there. This is one we used in jury selection. So what mitigation is? It's evidence a juror might regard as reducing a defendant's moral blameworthiness. No circumstance or event is
Your
necessarily
Honor,
mitigating.
This is not the law, Your Honor, and we object to it being displayed to the jury.
It is the law.
I'll overrule.
If you look at the charge. It tells you what mitigation is. It tells you that mitigation is evidence that might reduce a defendant's moral blameworthiness. And what have you heard that reduces this defendant's moral blameworthiness? When you compare, and if the question's asking, it's very specific. It's saying, think about everything you've heard since day one of this trial. The facts and circumstances of the capital murder itself, right? The defendant's character and background, and the personal and moral culpability of the defendant. And you need to ask yourself, first of all, do I believe it? Do I believe it exists? Only if you believe
Your
it.
Honor, we object. This is not the law. It's the suggested format, and they don't have to. She's saying you need to do this. The law does not require it, Your Honor.
All right, members of the jury, you have all the law before you in the court's charge. That law has not changed since I've given it to you. It's all the law that you will need and can use during your deliberation.
Do I find the circumstance to be mitigating? Does it reduce the defendant's moral blameworthiness? And if I find it does, whatever that circumstance or event may be, is it sufficiently mitigating when I compare it to everything else? The capital murder, his character and background, and his personal moral culpability. And the circumstances of the offense. Here's what I think is really interesting. When you look at the evidence that was introduced, that was taken from his car when they searched his car, he had an opportunity to be at work this day at Labor Max, November 20th, 2016. But he chose not to go. He chose not to work. And really, remember his testimony to Detective Duke, his interview. And to the media interviews as well. All I do is work, 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 work. Well, he chose not to go to work so he could take out his anger on the system that day, on Detective Marconi. And you've seen this. This is the video of the defendant pulling up behind Detective Marconi, getting out, running to the car, shooting him, leaning in, shooting him, getting back, and taking off. And what do we know? Look what he did. This is his handiwork. This is how he left Detective Marconi. It was up close. It was personal. And what did Detective Marconi ever do to this defendant? What did he ever do to him? Did he deserve this? And it comes out of his neck. The first shot goes in his cheek, comes out of his neck. And you see in that first video, the interior of the vehicle, how he puts his hand on his face. And he's still alive. He is still alive when the defendant puts the second shot into the back of his head and pulls the trigger. A choice. And the bullet blasts out of his head. The circumstances of the offense. You consider that when you're looking at everything else. And this is Detective Marconi when he arrives at the morgue. Because of him. Because of what he did to him. But if we don't focus on that, then it doesn't seem like a future danger, right? If we don't focus on this, if we ignore this, if we focus on other things that are really insignificant, then it's easy for you to find that he's maybe not a future danger, but the evidence shows otherwise. The defendant's character and background, and the personal moral culpability of this defendant. You heard defense witnesses to testify as to both of these subjects. His best friend from high school, Reggie. And when we talk about mitigation, something that reduces someone's moral blameworthiness, we talked about in jury selection that there are individuals who are on trial for whatever, offenses, serious offenses, who have been physically abused as a child, who have been sexually abused as a child. But we don't have that here. We don't have that at all. We have individuals who have lived in homes where there's been domestic violence such that the child feels it and it's a horrible experience, like Reginald Alderman testified. In fact, he left his abusive home to go live with the defendant and his family. We don't have that here. We don't have that the defendant had a rough childhood. They testified, they brought in his high school coach, and he said that he knew the defendant for 3 years. And I thought it was interesting when his mother, Sandra McKane, testified that she told us the defendant, her son got kicked out of Madison, and that's why he ended up going to Foxtail. But before she said that, we were left with the impression that through Reggie, right? When Reggie testified, we were left with the impression that the defendant had to take a bus for 2.5 hours across town from Nacogdoches area where he lived near Madison High School, and get on this bus and ride it to there, and then turn around at the end of the day and ride it back, and they wanted you to believe, oh, that's mitigating, that reduces his moral blameworthiness. But that's his choice. That was his choice, and his mother told you that. That was his choice because he wanted to play athletics, and she let him. There's nothing mitigating about that. Nothing that reduces his moral blameworthiness. And then they left the impression that through Reggie, and Reggie's his best friend, they talk all the time. But they left the impression with you that this defendant did all the housework, the cooking, the cleaning, going to HEB, providing for his siblings while his mother worked. And you saw her reaction to Stan when we asked you, said, no, maybe 2 times a week. But it wasn't an everyday occurrence. There's nothing mitigating. And she said it wasn't in middle school either. Maybe in 8th grade he would help out or so, or high school. But there's nothing mitigating about kids, older kids, helping while a mother or a father goes to work, helps out in the house. I mean, they're called chores. And we live in a family and we help each other out. And they brought, and the high school coach he hadn't seen the defendant in 13 years? Or longer. I mean, since the time of the capital murder it would have been 13 years. But since the defendant left in 2004, he hadn't seen him or spoke to him. So he just wants to tell you about this 3-year time in his life when he was a teenager. The defendant was 31 years old, a grown man, when he executed Detective Marconi. He wasn't a teenager. He wasn't 17, 18, 19 years old. He was long past Coach Burdock. And when you listen to the video or the audio with the defendant and his mother, he's laughing. He's telling her things. This is after the verdict, when he's bragging about how 8 officers beat him up. No one beat him up. He came to court. He looked fine. He wasn't beaten up. He's lying. He's lying to his mother. He's lied to his mother for years. He lied to his mother about the offense when she called him. Said, hey, people are calling me saying it looks like you, and he's denying it. He's lying to her. And his brother, Jeremiah, the defense said that he's telling, and Jeremiah said, he's telling, don't do what I do, don't do what I did. But yet he's not admitting what he did to his family. He's telling his family on the phone and his buddies, I'm innocent. He told Dr. Crowder that, his own expert, that I'm innocent, I didn't do it. So he's telling Jeremiah, don't do what I did, but in essence, I didn't do anything. So what am I, being held illegally or unlawfully in jail? What kind of message does that send to his brother? And we wish Jeremiah the best. He seems like a young, nice, well-spoken young man, and I hope, and I wish him the best. But it's this defendant's actions, not the actions of his mother or brother. He's the one on trial for what he did. And he's the one who you're looking at when you answer these questions. And then you heard the geographic information systems analyst and the psychiatrist. And Amy Wynn, she showed you those maps. Households with single mothers, poverty, unemployment, medium income in those decades. And she told you her focus is more on juveniles than anything else. And she goes around the country testifying with her maps in capital murder cases. That's what she does. That's how she's made her money, her living, for the last 13 years. And the thing that I think is interesting when you look at these maps, there are single mothers, like Miss McKane, who did everything she could for this defendant. She told you she always had a job. Her kids always had a place to live. He was never homeless. She provided food, everything he needed. He wanted to go to a different school for athletics. She allowed that. She gave him everything she could. There's no evidence that he ever wanted or needed, that all of his needs weren't met. And the unemployment. This is dealing with juveniles. Sandra McKane was employed the entire time. And she said here, I'm only here to present data and not form an opinion. And then she said, at the end of her testimony, I'm not making any correlation between my maps and the capital murder. So, what do you take from that? If she's not making any correlation, what's the point? And she had an opportunity to, in this study, you can do the community, the individual, peers, friends, school. And she chose only one. And it has no effect because these are maps from all over the city. And we're talking about this defendant, his family, and his choices. And she gave us no information. And what I thought was most telling is when Mario asked her, just on a common sense basis as a human being, wouldn't you agree that a person's own initiative, their own personal responsibility, can play a role in whether or not they're living in poverty? Based on 13 years of doing this work, I'd have to say no. So if an individual goes to school and graduates, like this defendant, goes to 2 colleges, and doesn't, and if they had the initiative, if they worked hard, that according to Ms. Wynn, they'll always be in poverty. That their own personal responsibility, the fact that they can work and do well and make money, they will always be in poverty based on what she said. It has nothing to do with choices, with people's choices. And the other thing, so then they talked about this cannabis-induced psychosis, and he says, I can't conclude that he was at the time. And I think the purpose of that was to show mitigation, that maybe He was in some sort of cannabis state, like he had smoked a bunch of marijuana. And so he was in the state, and that's why he killed Detective Marconi. And that's why the videos are significant. The videos, Detective Duke said when I interviewed him that it had nothing, he seemed coherent. He didn't seem to be under the influence of any alcohol or drugs. Eloy Brown at the Bexar County Jail said that. The next day, you saw the videos of him ditching the car, looking to see where he parked. At the Econo Lodge, he doesn't seem to be in some cannabis-induced state. He's getting married the next morning. He doesn't seem to be in some cannabis-induced state. Dr. Crowder told you that he knew, there's no question he knew right from wrong. He agreed, I agree that he knew what he wanted to do. The defendant has a lot of triggering mechanisms. Says he blames law enforcement for his life, his situation, instead of taking personal responsibility. And finally, Dr. Crowder said, I know I really can't believe him. Those are his words from the stand. And he was asked, does the defendant have a sense of entitlement? Yes. A sense of self-importance? Yes. A lack of empathy for others? Yes. And we know that. We know he has a lack of empathy from the statements he told Detective Duke after he killed Detective Marconi. He says it's about how people grow up. But you heard from his mother. He had a good life. I mean, it wasn't terrible. He didn't have everything he wanted. He wasn't rich, but most people aren't. He had food. He went to school. He had a home. He wasn't abused in any way, physically, sexually, verbally. He didn't live in a home that there was domestic violence going on. There's no mitigation here. And then I liked when Mr. Del Prado, Mario asked him about how would you categorize when the defendant ran up behind Detective Marconi and shot him twice in the head. He called it stealthy. Like a rocket. Stealthy. And you know why he chose that term? If he chose something else, like a coward, or if he called it evil, or if he called it whatever term, that makes him look bad, right? But stealthy doesn't make him look bad. And who hired him? They did. They hired him. He was paid. And he goes around testifying in capital murder cases for the defense. Dr. Crowder does. Case after case. That's how he makes his money too. Stealthy. Is that what you think he is, stealthy? He's a future danger. And the defendant has shown no remorse to anyone. And the fact that this case, when you look at his cell phone, and we brought that to you, he had multiple images of blocks, multiple searches on how to disassemble a Glock. In September, he has a search for the Round Rock Gun Show. This shows premeditation in the act itself. Then the day of, he has searches. He has searches and pictures of Detective Marconi, of his badge covered. He has pictures or searches or images on his phone from the crime scene. All that's on his phone. And finally, on his phone, he has an image from November 12, 2016, of a police officer, a deputy, who was killed a week before, who was shot twice in the head. And he has that on his phone. And if you pull up his phone and put it in the Cellbrite report, it's there. And we printed it out for you. Actually, I don't think it's in the tag part. It's in the other part, in the full extraction. But it's there. And we showed you the picture of that, and that's on his phone. And the defense saw it. Why would he have that on his phone? A week before killing Detective Marconi.
But my emotions got on me. I took it out in the first place myself. And, sir, man, I want to cry and apologize to this person and their family. But something in my heart just won't let me, man. I don't care about nothing, man, because I don't have nothing to live for. The only thing I want to do is hurt somebody because I know my life ain't nothing, sir.
Do you still feel that way?
Absolutely, man.
There's something in my heart that just won't let me apologize. This is the next day.
That's how I cover it up.
He's talking about how we covered up the evidence. These clips are kind of popping in and out. Let me try this.
That's how I cover it up.
What about your clothes? The clothes you were wearing
I do those away too. I do everything away.
in the same dumpster?
Yeah. I know that was one thing that y'all want to be able to time thinking, y'all knew what happened, and then if y'all did, all y'all could do was change my clothes and go where it comes. I do it in a random location, because whenever y'all found out, I knew that I had time for the garbage man to pick it up. I wanted to make the police station feel the burning I felt in my heart, sir. And I thought the only way of paying back this world before I leave is hurt somebody. The thought of me beating somebody up or shooting somebody, the only thing was soothe my soul at that moment. But knowing that I knew from the moment I pulled that trigger that wasn't the right thing to do.
Does he seem like he was in a cannabis-induced state when he was killing Detective Marconi? That's something that their expert testified to without having seen the videos?
I'm going to object.
Without having-
He stated he viewed this video, Your Honor.
Without viewing the videos of the capital murder itself and of the defendant going to the different locations where you see him.
I just want to ask the judge for mercy and just even though it might not be fit or deserved.
He's asking for mercy for what he did, and he knows it's not fit or deserving. And what mercy did he show Detective Marconi? He could have kept driving when he saw them there and not made that U-turn. He could have driven past him, but he didn't. He showed no mercy to Detective Marconi. When he ran to him, pulled out that Glock, shot him in the face, and then put it in the back of his head and pulled it again. But he wants you to give him mercy. when you look at all the evidence in this case, for special issue number 2, you have to take, the law is saying, the circumstances of the offense, the capital murder itself, the defendant's character and background, the personal moral culpability. This is someone who hasn't shown an ounce of remorse throughout any of the statements he's made that we have presented in court. Nothing. And he's still denying it to his family, to his doctor. This isn't something where he's saying, he's told his family or his doctor, I'm sorry, I regret what I did, I wish I could take it back. He's saying I didn't do it. It wasn't me. I'm innocent. But when you take all of that, and the fact that he did it himself, it wasn't an act where he was a party or anything else. He's the sole actor. But when you take in his character and background, his background, he hasn't had an abusive life. He hasn't, meaning he wasn't abused as a child. His life has been fine. Growing up in his home with Ms. McKane and his siblings. But when you take all that, what is the sufficient mitigating circumstance? Not just a circumstance. Sufficiently, when you consider everything you've heard in the case, what is sufficiently mitigating that he should receive life without parole over the death penalty? There's been nothing, no evidence that there is a sufficient mitigating circumstance. Not just mitigating, not just a circumstance, but it has to be sufficiently mitigating when you consider everything else you know. And mitigation is evidence that might reduce a defendant's moral blameworthiness. What have you heard? What have you heard that reduces Otis McKane's moral blameworthiness?
To comment, we object, Your Honor, to comment on the defendant's right to remain silent.
I'll sustain.
Yeah. My statement is, what evidence have you heard?
Disregard that last comment by the prosecutor.
Members of the jury disregard that last comment.
We request a mistrial, Your Honor.
Denied.
From the witness stand and from videos and audios and everything that's been introduced into evidence, what evidence have you heard that reduces this defendant's moral blameworthiness? Nothing. You haven't heard any evidence. Not a single bit of evidence that reduces his moral blameworthiness. And remember your oath. This is the most important part of this trial, is your oath. A true verdict, you're swearing, and you have sworn, a true verdict rendered according to the law and the evidence. So help you God. We have proven to you beyond a reasonable doubt of this defendant's future danger. You have a responsibility as a jury to see that justice is done. For every person this defendant may come in contact with. But you're not responsible. You are not responsible for what he has chosen to do. These are his acts and his acts alone. And on special issue number 2, when you think of everything else, everything that you've heard, the capital murder itself, the defendant's character and background, which includes his crimes, beating Zaharia, threatening to kill her, threatening his cousin with a butcher knife, selling drugs, caught with drugs, attacking the bailiff, and his personal moral culpability. He's still telling his doctor and his mother, wouldn't he? Has shown no remorse in any of his conversations with them. There's not a sufficient mitigating circumstance that he should receive life over death. And if you take your oath seriously and you take it truthfully, the answers to these questions. Special issue number 1, yes, and special issue number 2, no.
There was no justice in what I did.
And you know that. He's telling you that. Every witness that's testified had told you that. There's no justice in what he did. He showed no mercy on Detective Marconi. And Detective Marconi's favorite quote, evil triumphs when good men and women do nothing. This defendant's acts are pure evil. Pure evil what he did to Detective Marconi. And this is it. This is the defendant, what he did to Detective Marconi. And think about his family. You heard JC, his stepdaughter, testify. You heard his brother, how they got the call that the police came to their home. That has to be the worst feeling I can imagine. As a child, as a parent, as a sibling, when the police show up at your house unexpectedly, when you know that your brother, your father, is a police officer and you've heard that a police officer was shot. And they get that knock at the door. And they were told, you need to come with us to SAMC. They're not given much information. And they get there, and this is their last memory of Benjamin Marconi. Tubes in his mouth, blood, lifeless. That's their last memory of him. And wouldn't you know, this family right here, wouldn't they give anything to be able to see him? To visit him on Sundays, Saturdays, Sundays at jail, like this defendant's family came? To write letters to him? To tell him that they love him? To put money on his books? To pay for his commissary? Wouldn't they love just to have 1 minute with Detective Marconi? With their brother, their father? But they didn't get to, because he chose to execute him that day. Because of the badge. This was an attack on the San Antonio Police Department. You have a responsibility, but you're not responsible. You're not responsible for his actions, for what he chose to do. This is Detective Marconi. This is how he left him. And think about everything that Detective Marconi doesn't get to do. He loved his job. He was a dedicated police officer. And the defense has made a big deal about this case being a capital because he was a police officer. But officers put their life on the line every single day. And you told us, each one of you in jury selection, that based on the fact that he was a police officer, no, there's not a single one of you who said that I have a problem with that law. Not a single one of you said that. And not a single one of you said that you cannot follow the law and render a true verdict based on the evidence. And Detective Marconi's grandchildren will never see him again. And think about Mason, that picture that we showed you of him holding Mason upside down. And then the other children. JC's, she has 2 kids and one on the way, and his son Dane has another child. They'll never get to be with their grandfather. They'll never get to celebrate with him their first birthday, their second birthday, their first day of school. He'll never get to see him learn how to ride a bike. He'll never get to see him play any kind of sports. Basketball, football, volleyball, right? He'll never get to see any of that because of this man, because of what he did. This is why we're here. And when they tell the grandchildren, the family tells the grandchildren, well, what happened? What happened to the man that killed my grandfather? What happened? What did he get? Will he ever hurt someone else
For
again?
Your Honor, that's not a reasonable deduction of the evidence, and it wasn't introduced in the evidence, Your Honor.
I'll sustain.
By your verdict, will this defendant ever be able to hurt anyone again? You have a responsibility to follow that oath. And a true verdict under the law and the evidence means that this defendant is sentenced to death. Thank you.
All right, members of the jury, you now have all the evidence before you, and you have the law through the charge of the court. You have the closing argument of counsel. We're going to remove you from the courtroom, take you to the jury room. We're going to make sure the courtroom is emptied, and then you'll return to this particular courtroom. When all of you are assembled, then you may begin your deliberations. We'll be in recess until you've reached your verdict. I do need to have the two alternates stay behind. The rest of you are excused.
All rise for the jury.